Hey out there, legal warriors. 3 mistakes to avoid if you have a probation officer on a criminal case in Washington State. If you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get to see it. More people will get the help they need. Now, as always, I'm just going to jump right into it. Let's start out with an important caveat. What do I mean by a probation officer? And there's what we call probation officers, is what most district and municipal courts call the people that monitor sentences and monitor compliance of a defendant that's either been convicted or is otherwise subject to monitoring by the court. And that's for misdemeanors and gross misdemeanor cases. Now, for felonies, why the public might think of a probation officer in Washington State, for felonies, they're called CCOs, Community Correction Officers. And that's sort of a different type of probation. That probation is called community custody. That's a whole different area of the law than what I'm going to talk about in this video. For the vast majority of people who have any type of probation officer, it's not going to be for a felony. It's going to be for a non-felony, a misdemeanor, a gross misdemeanor. And what's that name, officer? Are they a law enforcement officer? Are they the police? No, typically not. It's just sort of what the court might call the people that work for the probation department. They don't need to be sworn in or have an oath or anything like that. Any of us can get a job if we apply as probation officer. Think of the probation officer as someone that works for the court that helps the court monitor the people that are under the jurisdiction of the court. Is it possible to have a probation officer even if you're not convicted of anything, even after your first court appearance? Unfortunately, yes, it is actually possible. Several counties do that, where you have a DUI or something, then they put you on pre-trial probation. Now, I don't like that. I sort of think that's restricting rights to a certain degree that I don't agree with. But the court would say that I, as the judge, am allowed to set conditions of release to protect the public. And if I want to run my court in a way where I have someone called the probation department or probation officer make sure that the defendant subject to my jurisdiction as the court is doing the right thing, I can do that if I want. I can run my court how I want. And it's just the reason why I don't particularly like it is because, to me, it seems sort of unnecessary because it puts a lot of burden on the defendant, a lot of reporting, a lot more missing work, and can create problems. So, probation officer is a person, man or woman typically, that works for a court doing what the court wants them to do. And usually what the court wants them to do is make sure that the defendant or the person who is charged with the crime is doing the right thing and not doing the wrong thing. What's the right thing? Well, could be doing certain classes or providing proof of treatment. It could be, showing that you're maintaining work and things like that. What's the wrong thing? Well, the wrong thing is, using controlled substances or drinking when you're not supposed to, missing probation appointments, missing court dates, or the big no-no, new crimes. Right? New crimes equals a big problem if you're under the jurisdiction of a court. So now I promised 3 mistakes to avoid. So now that I've sort of explained what a probation officer is and isn't, and what I'm talking about, non-felony situations here, the first big mistake to avoid, even after hearing all of that, is treating the probation officer like the enemy. The probation officer is not the enemy, at least if you want to think about it as, if you think about the probation officer as an enemy, you might be setting up yourself for failure because that attitude may come off with the probation officer. They're a person who has a lot of stress on them and they have a lot of power. So we don't want to upset them and get off on the wrong foot. I typically tell my clients, think about the probation officer as someone that's trying to help you make sure you keep the court happy. And we want to keep the court happy because the court is the one that has the power to revoke our freedom, right? And define us and do things to us that we're not going to like. And if a court is relying on a probation department, their word is God, pretty much, okay? In other words, if a probation officer says you've done something wrong, your attorney is going to have a chance to fight about it. And sometimes we do successfully fight about it because, unfortunately, there are some probation people that have, sort of off the farm, so to speak, in the way they're so strict about things and they can look ridiculous. But that's the exception, not the rule. But we want to keep that probation officer friendly to us, so let's act friendly towards them. Let's realize that they're charged to help the suspects, the defendants, do what the court wants. So if you have a first meeting with the probation officer, go in and think about it that way, right? That doesn't mean we just blab our whole life story and talk about all types of things that maybe we wouldn't want people to know, and that's going to be covered in tip 2. But what we really, really want to avoid is that make a probation officer have it out for us, because anyone in power, anybody in power, police, judges, attorneys, politicians, teachers, people with power have the ability to use that power for good and for bad, for petty reasons, for legitimate reasons. So let's avoid getting in the crosshairs in a negative way of a probation officer if we can. So what is mistake 2 to avoid? Well, now it's the other side of the spectrum. Am I talking out of both sides of my mouth? Well, I'm a lawyer, but no, I'm not. Step 2 is let's not volunteer negative things if we can avoid it to the probation officer, right? If they ask us a question and we can give a legitimate straight answer, let's give the straight answer. Let's not start bad-mouthing the victim or talking about how you went drinking and driving last night. Let's not talk about other crimes, right? If you're on probation and you're not allowed to drink, don't talk about how you went out to the bar last night for the dart tournament, because that's going to perk up someone's ears, right? We don't want to show up to a probation department with alcohol on our breath if we can't drink. We want to avoid, while we want to treat that probation officer not as the enemy, we still have to treat that probation officer with caution, because it's not a casual day-to-day conversation with your best friend or a coworker. They're listening for different things, right? Probation officers listening for criminal activity, listening for violating any conditions like victim contact, right? Oftentimes there might be a no contact order and you talk about, casually, let slip that, that the protected party met you in the park with your kid to see your kid. Well, depending on how aggressive that probation officer is, that might set you up for a new crime, a violation, things like that. So we want to be smart when we try to realize, while we don't not treat them as the enemy, they still are listening for things that could get us in trouble. And that moves on to the mistake number 3 to avoid. And this would be the mistake to avoid is forgetting to talk to your attorney about things prior to meeting with a probation officer. If you have something that's happened, you have another possible law enforcement contact. If you can't drink and you did drink, if you got a positive UA, if you got arrested out of county, check in with your attorney, right? Check in with your attorney about how it is you should handle that with a probation person. Right now, you might be required under the terms of a sentence to disclose certain things to probation, right? And you're still going to decide if you're going to, how you're going to live with that requirement, if that is one. How are you going to do that? And sometimes us attorneys, we come in and a client has, talked about a new crime they've committed, and probation, then brings it to the court's attention. And if you did that, well, that's already happened. Us attorneys might say, well, at least they reported it themselves, Judge, right? They should get some credit for that. But sometimes there might be law enforcement contact, and it's never discovered by the court or by a probation department. And therefore, there's pluses and minuses, but the mistake to avoid is sort of keeping it quiet and not talking to your defense attorney, where you have a privilege with, right, an attorney-client privilege. They can't go, talk to probation and get you in trouble for you talking to them. We have to remember what the relationships are. So that would be the third mistake I want you to avoid. And just overall, if I want to talk about, bonus material here as far as, how probation works, most of the time the probation department is just going to be looking for treatment updates. Hey, did you do your alcohol class? Did you do your domestic violence class? They're going to run your record and see if you have any new arrests or charges. That's mainly what they're going to be doing. What aren't they going to be doing? I just got this question yesterday, and that's why I got the idea for this video. The client asked me, hey, are they going to come visit my house? Right? Are they going to come visit my workplace, then come visit my home? And while every probation department is different, in my 30 years of being an attorney, I've never seen that happen on a non-felony matter. That's more for those CCOs, those community correction officers that we're talking about. Almost certainly, if you have a felony conviction where you're going to be on community custody with an actual CCO, they are going to check your workplace. Typically, they're going to come to your home because only certain very serious crimes have community custody. It's sort of like you're still in jail in a way, okay? But as far as for misdemeanor levels, while they might technically have the power to do so, I've never seen it happen. I don't know. It would be really, really unusual. So think about them as making sure the paperwork's right. If there's a non-compliant treatment report, sometimes a probation officer might give you a chance to come back in compliance. Sometimes they might just send it straight to the court. Talk to your attorney if you have concerns, because your attorney, if they're experienced and they have a sufficient volume of cases to have a lot of data, they'll have a pretty good idea of how a certain probation department or probation officer works versus how they don't work. The most important thing is if we just can stay out of trouble and do what we're supposed to do, that probation officer is going to give a really good report to the court, going to be really happy with you, and you're really going to be much happier with the outcome of your matter. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. I've been doing this for a long, long time. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.